Power of eminent domain. The power of eminent domain is also known as power of expropriation. The constitutional provisions on the power of eminent domain includes Article 3, Bill of Rights, Section 9, which states, private property shall not be taken for public use without just compensation. Article 12 on national economy and patrimony, Section 18, which states, the state may, in the interest of national welfare or defense, establish and operate vital industries and upon payment of just compensation, transfer to public ownership utilities and other private enterprises to be operated by the government. And Article 13 on social justice and human rights, Section 4 and 9, Section 4, which states, the state shall by law undertake an agrarian reform program funded on the right of the farmers and regular frame workers who are landless to own directly or collectively the lands they till, or in the case of other farm workers, to receive just share of fruits thereof. To this end, the state shall encourage and undertake just contribution of all in the agricultural lands, subject to such priorities and reasonable retention limits as the Congress may prescribe, taking into account ecological, developmental, or equity considerations and subject to payment of just compensation. In determining retention limits, the state shall respect the right of small landowners. The state shall further provide incentives for voluntary land sharing. Under urban land reform and housing, still under Article 13 of the Constitution, Section 9, the state shall by law and for the common good undertake, in cooperation with the public sector, a continuing program of urban land reform and housing, which will make available at all affordable cost decent housing and basic services to underprivileged and homeless citizens in urban centers and resettlement areas. It shall also promote adequate employment opportunities to such citizens. In the implementation of such program, the state shall respect the right of small property owners. Power of eminent domain distinguished from police power. Police power is the power of the state to promote public welfare by restraining and regulating the use of liberty and property. The power of eminent domain is the inherent right of the state to condemn private property to public use upon payment of just compensation. Although both police power and eminent domain have the general welfare for their objective, the recent trends show a mingling of the two, with the latter being used as an implement of the former. There are still traditional distinctions between the two. Property condemned under police power is usually noxious and intended for a noxious purpose, hence no compensation is paid. Likewise, the exercise of police power, property rights of individuals are subjected to restraints and burdens in order to secure the general comfort, health, and prosperity of the state. Where a property interest is merely restricted because the continued use thereof would be injurious to the public interest, there is no compensable taking. However, when a property interest is appropriated and applied to some public purpose, there is need to pay just compensation. In the exercise of police power, the state restricts the use of private property, but none of the property interest in the bundle of rights which constitute ownership is appropriated for use by or for the benefit of the public. Use of the property by the owners is limited, but no aspect of the property is used by or for the benefit of the public. Deprivation of use can, in fact, be total and will not constitute compensable taking if nobody else acquires use of the property or any interest therein. If, however, in the regulation of the use of the property, someone else acquires the use of the interest thereof, such restriction constitutes compensable taking. From the case of the DPO Earth Savers Multipurpose Association versus Guzon 2006. It is well settled that eminent domain is an inherent power of the state that need not be granted even by fundamental law. Section 9, Article 3 of the Constitution, in mandating that private property shall not be taken for public use without just compensation, merely imposes a limit on the government's rights of this power and provides a measure for protection to the individual's right to property. An ejectment suit should not ordinarily prevail over the state's power of eminent domain. From the case of Republic v. Tagle, 1998. The acquisition of an easement of right-of-way falls within the purview of the power of eminent domain. From the case of Camarines Norte Electric Cooperative versus CA, in National Power Corporation versus Manubay Agro-Industrial Development Corporation, it was reiterated that an action for a right-of-way filed by an electric company for the construction of transmission lines falls within the scope of the power of eminent domain. In Republic versus PLDT, the power of eminent domain normally results in the taking or appropriation of title to and possession of the expropriated property. But no cogent reason appears why the said power may not be availed to impose only a burden upon the owner of the condemned property without loss of title or possession. It is unquestionable that real property may, through expropriation, be subjected to an easement of right-of-way. Jurisdiction over a complaint for eminent domain is with the RTC, while the value of the property to be expropriated is estimated in monetary terms. The court is duty-bound to determine the amount of just compensation to be paid for the property. It is merely incidental to the expropriation suit. From the case of Barangay San Roque, Talisay, Cebu versus heirs of Francisco Pastor, 2000. This is reiterated as well in Bardillon versus Barangay Masili, Calambang, Laguna, 2003. In expropriation cases, there is no such thing as a plaintiff's matter of right to dismiss the complaint, precisely because the landowner may have already suffered damages at the start of the taking. The plaintiff's right in expropriation cases to dismiss the complaint has always been subject to court's approval or to certain conditions, from the case of NPC versus Pobre, 2004.